not one person who served as a whip for any political party and from whom the inquiry has obtained a statement recognises what Tim Fortescue told the BBC. There is nonetheless an issue for the inquiry to investigate here, whether it's true that the whip's offices of any party failed to report or worse assisted in suppressing allegations or evidence of child sexual abuse. There are also accounts of so-called dirt books kept in the whip's offices in which information about MPs, including personal information and information about potential or actual scandal, was recorded. Giles Brandreth, in his book Breaking the Code, Westminster Diaries, gives an account of the fabled black book, as he called it, at page 325. And I quote from that: "In his hand, the chief whip has the whip's notes, which he proceeds to read aloud. This, I understand, is as close as we get to the fabled black book. There's a huge old-fashioned safe in the corner of the office. Inside the safe are a couple of notebooks. Whips are expected to use them to record any intelligence that may be of interest as concisely as possible. There's a top copy which is torn out for the chief to read out. The carbon remains in the notebook. I get the impression, in brackets, early days, that the notes are to gauge general mood, in brackets, tittle-tattle from the tea room. Any significant information should be taken to the deputy in the first instance. He will then decide whither it goes," unquote. Later he refers to a new policy on whip's notes after what seemed to be a dispute about who owned them. The message was to keep writing the notes as the chief whip, and the Prime Minister needed the information. But, he says at page 388, quote, "Sleep easy, boys. From now on, the notes will be shredded on a regular basis," unquote. In writing his diaries, Mr. Brandreth considered that he was breaking the whip's code of silence. As he said in his statement to the inquiry, quote, "Whips never talk about what they do or how they go about it. That's the rule. As the chief whip pointed out to me at the time, quote, our mystery is part of our potency," unquote. But mystery makes for mischief. The trouble with operating in secret is that it encourages those not in the know to believe that dark deeds are being done in the murky corridors of power. Occasionally, perhaps they are, but mostly they are not. This part of the investigation will, it's hoped, remove more of that mystery. Ken Clarke, MP, has also described the practice of keeping whip's notes. In his book, Kind of Blue, a political memoir, Mr. Clarke said at page 59, quote, "The most striking rumours and reports of the political and private activities of Conservative MPs had to be recorded by each whip in a small book which was kept locked in the chief whip's office and which was only consulted by him. I think that Francis," and that's a reference to Francis Pym, "as all his predecessors did, kept this book as his personal possession, and he probably followed what was said to be the practice of all his predecessors by destroying it when he lost office, in order to protect some of our colleagues from the risk of posthumous scandal at the hands of later historians," unquote. As to what the whips may have known about MPs and their activities, Giles Brandreth said in the July 2014 afterword to his diaries at page 522 that, quote, "In my time in the whip's office, we helped people with mental problems, marital problems, drink problems, financial problems, and more besides. But I don't know of any case where we covered up for anyone who we believe to be guilty of a serious criminal offence," unquote. The inquiry is going to hear from Mr. Brandreth, Mr. Clarke, and other current and former whips as to the existence or otherwise of dirt books and what was known by the whips. We'll see an example of Whip's notes, which have been retained and which give some insight into the kind of information noted about MPs and their activities. We'll also hear how the practice of keeping such notes varied among political parties. We'll also hear from the private secretary to the government chief whip, Sir Murdo Maclean, who was in post from 1978 to 2000, a long period of time spanning much of the time of interest to this investigation. The fifth topic is the honour system, a system operated on behalf of the Crown by senior politicians and civil servants within the Westminster establishment. Concerns have been expressed publicly about honours granted to individuals who've been accused of child sexual abuse or where allegations of this nature were made after the honour had been granted. In the Rochdale investigation, the inquiry did examine concerns of this nature relating to Cyril Smith, but at that stage the inquiry didn't have available to it documents relating to the way in which other similar cases had been treated in relation both to the granting and to the forfeiture of honours. We intend to build on that work in this investigation. At our request, wide searches have been conducted by the Honours and Appointments Secretariat within the Cabinet Office, and the Cabinet Office has also provided a witness statement in response to a Rule 9 request that we have sent. We propose to call the Cabinet Office witness to give evidence next week in order to address the areas of concern that I have just identified. The sixth topic, the Pedophile Information Exchange, or PI. Evidence about this will be called at the beginning of the third week of hearings. Mr. Hulbert, the former Home Office employee and a core participant in this investigation, has provided the inquiry with a witness statement that goes to the question of whether PI may have received government funding in the late 1970s. To be more specific, the suggestion that Mr. Hulbert makes is that in or about 1976, the Voluntary Services Unit, the VSU, of the Home Office, which made grants to charitable organisations, provided funding of at least £30,000, some £214,000 in today's money, to PI. Mr. Hulbert worked at the VSU at the time and says that he saw documentary evidence indicating that one or more payments had been made to PI, disguised in VSU records as a payment to the Women's Royal Voluntary Service, the WRVS as it was at the time, now the RVS. Mr. Hulbert says that he took this matter up with his immediate superior at the time, a man named Clifford Hindley, now dead, and that Mr. Hindley admitted that money was being paid to PI, but said that this was being done at the request of Special Branch in order to facilitate an investigation into the group. Mr. Hulbert came forward initially in late 2013. He gave a statement to the police and he also spoke to the press. His story received prominent coverage by way of example, The Telegraph on the 10th of July 2014 under the headline, "Westminster Whistleblower Told to Back Off Over Pedophiles." Mr. Hulbert's allegations were examined by the Internal Home Office review in 2014, which I've mentioned already, and again by the Wanless-Whittam review. The original review found no evidence that PI was funded by the Home Office's Voluntary Services Unit, and Messrs. Wanless and Whittam subsequently found nothing in registered files or in the testimony offered by contemporaries in and around the VSU that funding of PI might have taken place with the knowledge of the police or MI5 as part of an effort to infiltrate PI. But Messrs. Wanless and Whittam were not able to dismiss the latter suggestion entirely, and Mr. Hulbert has suggested that there is fresh evidence going to this issue from his former colleague, Reverend Alan Davis, that has not previously been considered. Sadly, Reverend Davis died last year, but we had already obtained a statement from him, and we will adduce that statement in evidence. We will call Mr. Hulbert to give oral evidence, and we hope to call evidence from the Home Office official who assisted Messrs. Wanless and Whittam to explain the inquiries and the searches that they undertook. We've also conducted inquiries of our own on this issue, and I have to make it immediately clear that none of those inquiries has been able to substantiate Mr. Hulbert's allegation. Searches have been conducted in Metropolitan Police Special Branch records and also in the records of special branch offices throughout the country. None of these searches has thrown up any documents which suggest that PI may have been funded by the VSU, whether at the request of special branch or at all. However, it seems that there was a special branch file open on PI in July 1978 that was destroyed in 1999 in accordance with their standard destruction criteria. Searches have also been conducted by the Security Service MI5. There also no documents were found that provide any support for the suggestion that PI may have received Home Office funding. Indeed, one document that we have found at the Security Service is positively inconsistent with the allegation, and it's an internal MI5 Security Service note dated in 1983, which I'll ask to go up on the screen, INQ 004034, page 3, right at the top, if we can expand that. Under the heading Finances, a Treasurer's report, which was compiled in October 1982, showed that there was £460.48.5 in the PI's account. Recently, PI's finances are thought to be in a parlous state. There is no evidence of any other source of funds except from the membership. Thank you. We've reviewed a substantial quantity of PI's own documentation dating from the 70s and 80s, which are contained in an archive at the London School of Economics. These documents include internal records, such as minutes of meetings, correspondence, and copies of PI's various publications. As the Security Service note suggests, a shortage of funds is a theme of all this material. There is no hint in any of this material that at that time in its existence, PI had available to it anything like the level of finance that Mr. Hulbert suggests it received from the VSU. Finally, Tom O'Carroll, who, as I've said, was on the executive committee of PI, was its secretary and chair, has been asked the direct question whether PI received funding from the Home Office. We won't be calling him to give oral evidence, but he has provided the inquiry with a witness statement, which we will invite you to adduce, or at least part of it, during the course of this investigation. In summary, Mr. O'Carroll denied that PI ever received any funding from the Home Office or from any other person or organisation of anything like the amounts involved. He says, quote, "When I first heard the claim that the organisation had received up to £70,000 of government funding, I was stunned that anyone would make such a preposterous suggestion. We received not a penny of public money. We always operated on a shoestring. To the best of my knowledge, there were never any large donations to PI of any sort, including personal ones," unquote. He agrees that charities that worked with PI or met with PI members, such as the Albany Trust, may have received government funding. I should add that O'Carroll, of course, is an unrepentant paedophile who has convictions for conspiring to corrupt public morals and also for child pornography offences. So what weight you give to his evidence will, of course, be a matter for you. You may think not very much, but on this issue at least, he is consistent with the other evidence to which I have referred. Moving on, We will call evidence from Jeremy Clark, a trustee of the Albany Trust, to explain the relationship between the Albany Trust and Pi in the 70s and 80s, and the suggestion that Pi may have benefited financially from that relationship. We will also call evidence going to the relationship in the same period, the 70s and 80s, between Pi and the organisation now known as Liberty, at the time the NCCL, National Council for Civil Liberties. This matter has already been the subject of a certain amount of public comment, and indeed it was the subject of a statement made in 2014 by the then Director of Liberty, Shami Chakrabarti. However, some of the documents that we have seen during the disclosure exercise suggest that there are questions for the inquiry to explore on this issue. The inquiry has received a statement from Liberty's acting director, Miss Corey Stoughton, addressing these issues, and will invite you to adduce that statement in evidence. And the final topic, topic 7, is about safeguarding policies, which looks not to the past but to the present and the future, relating to the issue defined in paragraph 2.3 of the definition of scope for this investigation as, quote, the adequacy of existing safeguarding and child protection policies in place within political parties, in government departments and agencies, and in the intelligence and security agencies, unquote. You'll hear evidence about this in the third week of the hearing. As I've already indicated, we have requested and received disclosure of current safeguarding policies from political parties, from a large number of government departments and agencies, and from the Palace of Westminster. We've instructed Professor June Thoburn, who is the Emeritus Professor of Social Work at the University of East Anglia, to consider the policies and to prepare a report addressing their adequacy in various respects. I'll not take time going through the detail of Professor Thoburn's report now, but to give a flavour of it, she considers that child safeguarding policies and procedures appropriate to the function of each government department, the Palace of Westminster and all political parties are essential, even though it may not be immediately obvious that it is something that they need to consider. She says it's the level of access to children and or level of contact with children which determines the appropriate levels of safeguarding measures to be taken by government departments, political parties and other organisations associated with Westminster. She recognises that some departments will have more direct contact with children than others, and some will have express functions with regard to child protection and safeguarding, but this shouldn't lead organisations to think that child protection safeguarding is not relevant to them. On the contrary, Professor Thoburn recommends that awareness of child abuse, including all forms of sexual abuse, online abuse and sexual exploitation, and the need for employees to be alerted to the importance of child safeguarding should have a higher profile within the overarching policy statements of all government departments and political parties. And on the back of her analysis, she makes 13 recommendations for the inquiry to consider. We'll also receive evidence from MI5, MI6, and GCHQ regarding their current practices and policies regarding children at risk, given its focus on Westminster and persons of public prominence. It's of particular interest to focus, it's of particular interest to this investigation to examine how the security and intelligence agencies would now deal with any information that they may receive that raises concerns regarding child sexual abuse by way of comparison to specific historic cases. A few other points before I conclude. First, the disclosure exercise. As I hope will be apparent after what I have said so far, a considerable amount of work has gone into obtaining and preparing evidence for this investigation. As part of that effort, as in all of the inquiry's investigations, we've undertaken a major disclosure exercise. Documents were requested from a wide range of agencies and individuals. They include MI5, MI6, and GCHQ, each of whom states they found no material to show the existence of a so-called Westminster VIP paedophile ring or any attempts to suppress the existence of such a paedophile ring. The Cabinet Office, the CPS, political parties represented in Parliament, the IOPC, the Metropolitan Police, police forces nationwide in relation to Special Branch Archives and the Special Branch Archive of the Metropolitan Police, or the archive as it was once upon a time for Special Branch. It's no longer the Special Branch, held no material to prove the existence of a Westminster VIP paedophile ring or any attempts to suppress the existence of such a paedophile ring. Police forces, including Sussex and Wiltshire, regional forces via Operation Hydrant, the London School of Economics for records on the Liberal Party and Pi, the Bodleian Library and Churchill College, Oxford, as well as numerous individuals who hold relevant documents. All documents received by the investigation, many of them as a result of these searches, have been reviewed for relevance by the inquiry legal team, which has been a huge undertaking. The inquiry has received a total of approximately 103,300 pages from material providers in this investigation. All relevant documents have been redacted and sent to material providers for checking. Approximately 15,000 pages have been disclosed to core participants, which are the documents falling within the defined scope of this investigation. In some instances, there is a relevance in the fact that certain searches for documents covering a particular issue and or held by a certain organisation have produced a nil return. We'll adduce some evidence along these lines in the course of the hearings. Let me come now to the definition of child sexual abuse. This is a further point, and it regards the limitations on the scope of this investigation relating to the definition of child sexual abuse, to which I've already alluded. The terms of reference of the inquiry make clear at paragraph 6 that child sexual abuse refers to the sexual abuse of any person under the age of 18. And the definition has to be applied, bearing in mind a number of historical factors. Before 1967, homosexual acts were illegal in this country. In 1967, homosexual acts were decriminalised between men aged 21 and over. In 1994, the age of consent for such activity was reduced from 21 to 18, and in the year 2000, the age of consent for homosexual acts in private was lowered to 16, so that the age of consent in England and Wales is now 16 for all sexual acts, regardless of sexual orientation or gender. The consequence of this is that between 1967 and 1994, which is very much a period that this investigation is concerned with, homosexual acts between an older man and, say, a young man of 19 would have been unlawful. For that reason, such activity might well have been kept secret. But it wouldn't be within the scope of this inquiry because it didn't involve a child. The point matters because, as we shall see, the evidence from the time often refers to clandestine, illicit or secretive sexual activity between an older and a younger partner, usually both male, where the precise age of the younger partner is unclear. I've already referred to the term rent boy, which was used to refer to those under 18 whom the inquiry would regard as children, and those in their late teens and early 20s. For example, John Mann, MP, in his statement to the inquiry, says that the so-called Dickens dossier, a copy of which he says he was given, concerned allegations about sex between males aged between 16 and 21. These were primarily sexual encounters between persons of public prominence and so-called rent boys or male prostitutes. Although, as Mr. Mann points out, there may have been, quote, elements of coercion and violence and other illegality, unquote, involved in such encounters, it needs to be borne in mind that it's not within the scope of this inquiry to examine sexual activity between adults aged 18 or older. And I remind you, Lord Tebbit alluded to a similar distinction in his statement when he spoke about Peter Morrison having an interest in young men who he understood to be of about sixth form age, as did Edwina Curry-Jones in her statement when she noted that Peter Morrison's interest was in boys old enough to give consent with a female partner, but not with a male partner. Let me come now to redaction and publication of names. Chair, it's inevitable that as part of this investigation, the inquiry will hear evidence about a significant number of historical allegations which have been made about persons of public prominence associated with Westminster. As we made clear at the preliminary hearing in October last year, the inquiry has adopted its usual redaction protocol when preparing evidence for disclosure during the course of this investigation. That protocol does permit the naming of persons against whom allegations have been made, where such information is already in the public domain, that is, published in the regulated media. For the avoidance of doubt, I wish to repeat what I said earlier, that the fact that certain individuals will be named in this investigation does not mean that the allegations against them are true. This investigation is not examining the truth or otherwise of individual allegations. In naming any person about whom an allegation has been made, the inquiry is making no suggestion that the allegation is true or that the person committed the alleged act. The inquiry is simply addressing, in an open and transparent way, issues of public concern. Finally, procedure. In order to assist everyone's understanding, the evidence will be presented essentially in one of two ways. Witnesses will either be called live and their evidence simultaneously live streamed on the internet, or if not called live, witnesses' evidence will at appropriate points be read or summarised by counsel and formally adduced into evidence by such means. Documents, or parts of them that are referred to, will be published on the inquiry's website, and video clips that are shown in the course of the hearing will either be posted on the website or their web address will be given. Two of the witnesses we propose calling, MI5 and MI6 witnesses, have been granted anonymity, and as appear in a directions document which is available on the inquiry website, special measures are in place to protect their identities, as there is a real risk to their security. That means that they will not give evidence in their names and will be giving their evidence by remote video link and seen only by you and the panel, as well as by counsel to the inquiry. The evidence will not be live streamed, but everyone else, core participants, their legal teams, members of the public and press, will be able to hear and listen to the audio feed of their evidence in the hearing room or in the annex, and transcripts of their evidence will be available on the inquiry website at the end of the days on which they are due to give evidence. The audio feed of the evidence will not be uploaded to the website after the witnesses have completed their evidence. Audio recording of their evidence will be prohibited, but core participant legal teams in the hearing room will be able to use electronic devices, while accredited members of the press will be able to use live text-based services to report the evidence in real time. All other electronic devices will have to be switched off And that's all I wish to say on that topic for now. Chair, it's just after 1 o'clock. I suspect just after 2 o'clock. Each counsel for the court participants wishing to make an opening statement will have that opportunity, after which tomorrow we will turn to the evidence. Thank you very much.
Thank you, Mr. Alton. We will return from lunch at 2:05. Please sit down. We'll now hear from other counsel in the room wishing to make opening statements. I would remind everyone, please, to adhere as closely as possible to the time allocation you've been given. Mr. Scorer.
Chair and panel, Ms Harrison and I represent 7 men who make allegations of abuse by Cyril Smith. In the Rochdale hearings, you heard their very compelling and moving testimony. As was clear in those hearings, their allegations are highly credible. And as Mr Altman reminded us this morning, in 1970, following an exhaustive investigation, Lancashire Police recommended that Smith be prosecuted for sexual offences. Indeed, so keen were Lancashire Police to proceed with the prosecution that even before sending their recommendation to the DPP, they drew up a detailed indictment. You will also recall that in 1998 and 99, Greater Manchester Police also recommended that Cyril Smith be prosecuted for sexual offences. On all 3 occasions, Cyril Smith escaped prosecution. In 1970, the extensive case file from Lancashire Police was allocated to an assistant solicitor in the DPP's office. At the time of your Rochdale report, the identity of that individual was not entirely clear, but we now know that he went by the name of Michael Duncan Hutchison, and in all likelihood he is now deceased. This lawyer undertook only a very cursory analysis of the evidence and recommended against prosecution. He was so dismissive of the allegations against Smith that in today's terminology, his attitude could fairly be described as one of automatic victim disbelief. Lancashire Police evidently felt bound to accept the DPP's recommendation. There were suspicions that senior politicians had intervened with the DPP on Smith's behalf. In 1998 and 99, the allegations against Cyril Smith were deemed by the CPS to have passed the evidential test for prosecution, but Smith escaped justice because of previous assurances given to him, a decision you criticised in your Rochdale report. In the light of that history and the confirmation from the CPS in 2012 that Smith should have been prosecuted, the credibility of the allegations against Cyril Smith is not in doubt. The real question is how Smith was able to survive in frontline politics for so long, and whether he was knowingly protected by the Liberal Party and indeed by state agencies. Although many of the events in the Smith case date back some years, we believe that the case carries important lessons for the present day. Before I come to those matters, I want to mention a general point about our approach. Over the past few years, there has been much talk about so-called VIP paedophiles and the possible cover-up of child abuse by politicians, prosecutors, the police and security services. What might in contemporary language be called a deep state conspiracy. It would be fair to say that some of these claims have been very speculative and not grounded in reliable fact. Some of them may simply be a reheating of older and demonstrably false conspiracy theories. At the same time, in other respects, there are clearly very justified and legitimate concerns about how some prominent people seem to have escaped justice, and Cyril Smith is one of those. Our interest in this matter is simply to separate fact from fiction and to get to the truth, because the truth is the best basis on which to take action to protect children in the future. Allegations of state cover-up therefore need to be approached with an open mind, but also with rigour and common sense. That would always be the case, but is particularly so here. So returning to Cyril Smith's political career, I start with the position in 1970. At that time, Rochdale was a target seat for the Liberals. Cyril Smith was a larger-than-life character in the town, and we know from the evidence of the former Liberal MP Michael Meadowcroft that Jeremy Thorpe, the then Liberal leader, was very anxious for Smith to stand, as he was the only person who could win the seat for the Liberals. In October 1969, Lancashire Police instituted their inquiry into allegations of indecent assault by Smith. We also know that in late 1969 or early 1970, Jeremy Thorpe sent the national agent for the Liberal Party, Ted Wheeler, to Rochdale on a mission to persuade Smith to stand for Parliament in the upcoming general election. We also know that during Ted Wheeler's visit to Rochdale, he was informed by at least 2 people that there was a police investigation in relation to Cyril Smith's possible impropriety with boys. In January 1970, Smith visited one of his accusers, our client A1, and tried to intimidate him into withdrawing his police statement. In that same month, Smith had a meeting with Rochdale Police. He told them that he needed to know whether he was going to be charged, because if so, he would not stand for Parliament. He was categorical about this, stating in terms that if I'm going to be charged, I'm not going to accept the candidacy. He also pressed the police officer to tell him whether the DPP would be involved in the charging decision, showing that he was thinking ahead to the role that the DPP would play. In February 1970, he was interviewed by the police about the allegations, and then on 2nd of March 1970, Smith was adopted by the Liberal Party in Rochdale as their parliamentary candidate. Whether or not this decision required approval by the National Party, they were clearly aware of it, and there is evidence in the disclosure to this inquiry that some Liberals in the North West were angry precisely because they felt that Smith had been imposed on them by the National Party. So by this point, Smith and the Liberal leadership in London were evidently confident that he would not be charged. However, a striking aspect of this chronology is that his adoption as candidate took place before the police file was submitted to the DPP. It was only on the 13th of March 1970 that the file went to the DPP, and on 19th of March when it came back with the recommendation against charging him. Just pausing very briefly on the DPP aspect, of course you looked at that in the Rochdale hearing. There are 2 further points of relevance to this investigation. Firstly, as I've said, it's clear from the chronology that Smith felt confident in being selected as the Liberal candidate before the DPP had even received the police file, let alone pronounced on it, despite Smith having previously said that he could not be selected until he had certainty over the outcome. That obviously suggests foreknowledge on his part of the DPP's decision and confidence that it would go in his favour. Of course, there were suggestions at the time that politicians, possibly Jack McCann, possibly Roy Jenkins, had interceded with the DPP on Smith's behalf. Because of the passage of time, we may never get to the truth of this, but the timing of events is clearly circumstantial evidence supporting the theory that the DPP's decision was preordained. This raises a wider issue of concern, significant concern to our clients. As we've heard, in his statement submitted for this hearing, Lord Taverne, who was a political ally of Roy Jenkins, states that during Jenkins's time as Home Secretary, which was 1965 to late 1967, Jenkins was keen to avoid the arrest and prosecution of MPs and peers for homosexual offences, for example, cottaging, in order to avoid embarrassment, and that as a result, some prominent people were not prosecuted. The example given is Tom Dryburgh, MP. Lord Taverne indicates that this related to the prosecution of adult offences, and so far as he was aware, the issue of child sexual offences did not arise. However, it has been suggested by others that that line was blurred in relation to Tom Dryburgh himself. We also note that Tom O'Carroll, the former leader of PIE, claims in his statement that Jenkins was sympathetic to PIE's proposals to reduce the age of consent. That may presumably relate to the 1970s when Jenkins had a further stint as Home Secretary. Whether or not O'Carroll's claim is true, and we can't assume that he is a reliable witness, these various comments raise the concern that if powerful people did intervene with the DPP on Smith's behalf, they may have been pushing at an open door. Our clients are generally very concerned that the rightful liberalisation of the law and attitudes in relation to homosexual offences was misused or exploited to undermine the protection of children, whether through prosecution policy or in other ways. Returning to the events of 1970, it is clear that by the time that Smith was selected as Liberal candidate for Rochdale, the National Liberal Party were almost certainly aware of the allegations against him. Ted Wheeler was a central figure in national Liberal politics and organisation. If he knew about the allegations against Smith, then we say it is inconceivable that he would not have informed the national leadership, and this is supported by other evidence. Dominic Carman, son of George Carman, who defended Jeremy Thorpe in the 1979 trial, states that Thorpe told his father in 1979 that the allegations against Smith had been known about in Liberal circles for many years. We note that David Steele, now Lord Steele, says in his statement to this inquiry that he knew nothing of the allegations against Smith until 1979, when they were published in the Rochdale Alternative Press. That is clearly a matter to be explored with Lord Steele next week, but Steele was obviously part of the Liberal Party's national leadership from 1970 onwards, when he became Liberal Chief Whip, and we note that his denial of any knowledge at that time seems to be at odds with other evidence. We then move to the events of 1979 and the publication of the allegations against Smith in the Rochdale Alternative Press and then Private Eye. An important issue for our clients, and one which we believe has present-day implications, is how the Liberal leadership responded at that point, because the party's failure to act on the allegations in 1979 enabled Smith to carry on in public life and to go on to use his status and his power to abuse boys with impunity in the 1980s, at Knollview and probably elsewhere. Lord Steele says in his statement that when he became aware of the allegations in 1979, he asked Cyril Smith about them, and Smith's response was that he had been investigated and no further action had been taken. Steele himself then took no further action, and it seems that the Liberal Party press office was dismissive of the allegations when asked about them by the press. When assessing that response, 2 points need to be borne in mind. The first point is the quality of the information available to David Steele about these allegations in 1979. People following these hearings may not have seen the articles published in the Rochdale Alternative Press in 1979, and so may wrongly assume that this was no more than gossip mongering by some sort of scurrilous underground magazine, something along the lines of Scallywag, for example. Nothing could be further from the truth, and I urge anybody reading this, following this, to read the Rochdale Alternative Press articles, which are, I think, available on the inquiry website. They are detailed and scrupulously accurate. They set out the information then available about Smith's offending in a precise and careful fashion. They are not at all salacious. They confirm the nature of the allegations against Smith, the supporting evidence, the fact that Lancashire Police had recommended prosecution, the fact that a significant abuse of power was involved. These articles are a model of responsible and accurate reporting, and if the Liberals wanted to take action, the necessary information was there in the articles, or it was obvious from them where it could be found. Chair, in the next few weeks we will hear a lot about various dossiers. There may be debate about whether various dossiers were real or mythical, and whether, if they existed, they contained genuine evidence or simply rumour. But here, compiled by the Rochdale Alternative Press, was a real dossier worthy of the name. It contained actual evidence and testimony. It gave Steele ample basis for further investigation and all of the lines of inquiry to follow up, and he failed to do so. Secondly, it is also important to remember the contemporary context in 1979. Steele was leader of the Liberal Party and, as such, had spent much of the few years firefighting the impact of the Jeremy Thorpe scandal. From 1975 onwards, as details of Thorpe's illicit relationship with Norman Scott started to come to light, it became obvious that Thorpe had misled his parliamentary colleagues as to the nature and extent of his dealings with Scott. We say that having had that experience of discovering that a senior colleague had lied to him, David Steele had especially good reason to take the revelations regarding Cyril Smith more seriously and make his own inquiries rather than simply taking Smith's denials at face value. The fact that his own party leader had misled him about his private life ought to have put him especially on his guard. We note that Steele's attitude seems to have been that in the absence of a criminal conviction, there was nothing to worry about. However, the concept that there may be concerns about somebody, even when they haven't been prosecuted or convicted, is hardly a new idea. And if there was one person who ought to have understood it in 1979, it was the leader of the Liberal Party. That very year, his predecessor, Jeremy Thorpe, was acquitted at the Old Bailey of conspiracy to murder, but was acquitted in circumstances where there were obviously very serious issues about his conduct and where it was obvious that he had misled others about the nature of his relationship with Scott. Acquittal didn't mean there was nothing to worry about. It didn't make Thorpe suitable to return to Parliament. So we say that Steele should have made his own inquiries to determine whether Smith was a suitable person to be in public life and to enjoy the status and deference that came from being a senior parliamentarian. Of course, it may well be that in 1979 the very last thing Steele wanted was another Liberal Party scandal. In his autobiography, Lord Steele says that the Thorpe scandal caused, and I quote, acute misery to those at the top of the Liberal Party, and he describes the years 1975 to 1979, when the scandal unfolded, as dreadful. It may be that this was one reason why he turned a blind eye to the allegations against Smith. Just like we've seen with the churches, he may have felt that the best way to protect the party's reputation from a further battering was to avoid opening this particular can of worms. But the fact that the lessons of the Thorpe affair were staring him in the face makes his failure to act over Smith all the more shocking. Of the Liberal Party's failure to act against Cyril Smith, one of my clients says this: Cyril Smith was a monster. He actually needed treatment. The politicians who ignored his behaviour were just as bad as him. They used him to promote their party and they let me down. They made him an even bigger monster and they let him loose. We will obviously see what Lord Steele says about all of this in his evidence, but what is particularly disappointing is that there seems to have been very little effort by the Liberal Democrats to grapple with any of these issues seriously when they had their so-called inquiry in 2012. There was, we say, no real attempt to analyse what information was actually available to the party over the years about Smith. There was no real attempt to examine how the culture of the party and failures of leadership let Smith off the hook. One of the few senior Liberal figures who does seem to have reflected on those issues is Des Wilson, the former Liberal Party president. He describes Cyril Smith as a monstrous character and a bullying, selfish manipulator. Regarding Steele's failure to take action after the 1979 articles, he says that Steele's natural tendency would be to hide his head in the sand. We note that when Steele was interviewed in June 2018, 2 months after the publication of your Rochdale report, and despite all the information in it about the abuse by Smith, Lord Steele continued to describe the allegations against Smith as scurrilous hearsay and tittle-tattle. So the judgment that he buries his head in the sand about this seems pretty accurate. Wilson also addresses some of the features of party culture which contributed to the failure over Smith. He says that people were frightened of Smith and didn't want to confront him. He says that one problem was that many MPs in the Parliamentary Liberal Party had guilty secrets of their own, which they didn't want exposed. He confirms that coming so soon after the Thorpe scandal, a formal inquiry into Smith would have been politically catastrophic, and because the Liberal Party was so small, the loss of just one MP would have been very damaging. But in trying to understand the Liberal Party's failure over Smith, he seems to be largely on his own. So despite all the publicity and hand-wringing, the lessons of this case do not seem to have been learned by the people who need to learn them. Chair, I focus here on the Liberals because of Smith, but in reality I don't seek to single them out amongst the parties. The reality is that bullying, manipulators and an obsession with reputational protection exist in all political parties, and so there are lessons across the board. In the recent Challoner case in the Green Party, the Verita inquiry concluded that those in the party who were told about David Challoner's arrest and charges for serious sexual offences saw the issue as, and I quote, primarily a communications one about protecting the reputation of the party. Nobody considered the abused child. Political parties are run by activists seeking to win elections and gain power. They are not formed with child safeguarding in mind. Winning elections requires candidates to stand who can win and also volunteers to work for parties, often long unsociable hours, to campaign for them. If somebody within a political party is popular and charismatic figure who can win elections, those within the party may not wish to hear anything bad said against them. As the safeguarding expert instructed by this inquiry notes, many of those who work for political parties are volunteers. Hard-working volunteers are increasingly hard to come by. Tribal loyalties within political parties are very strong, and again it may not be seen to be in the interests of any political party to look too closely at any allegations that may arise. That is why safeguarding is so important, and within the disclosure we've seen that formal safeguarding policy and procedures within the main political parties in the UK range still from relatively comprehensive to virtually non-existent. Even those policies which seem comprehensive on paper at least are relatively recent inceptions of the last 18 to 24 months, perhaps with this inquiry in mind. And irrespective of formal procedures, it is clear that the culture of safeguarding has not yet been embedded into political parties and is still very unfamiliar to all of them, something that we hope this inquiry can change. Chair, I want to finish by commenting briefly on the various allegations suggesting that state agencies, for example police and special branch, were involved in shielding Smith and other prominent paedophiles from justice. We'll hear the evidence on this over the coming days, At this stage, we would say this. If it was the case that police, special branch or security services were protecting Cyril Smith and others from justice, then nobody has more reason to feel angry and betrayed about this than our clients. Sexual abuse is dreadful enough. The idea that the state and government then deliberately shielded the perpetrator adds insult to injury in the most appalling possible way. However, having waited so long for these allegations to be examined in this inquiry, our clients are also keen to ensure that the evidence is properly tested so that an accurate picture emerges. There are many allegations of state cover-up. Some of them we think have substance. You've heard our concerns about Smith and the DPP. However, it is also true to say, on reviewing the material disclosed by the inquiry thus far, that many allegations of cover-up are either uncorroborated or in some cases other evidence appears to undermine them. Taking just two examples of allegations of state cover-up with the Cyril Smith connection, we note the evidence of various police officers who were tasked with tackling vice in London in the 1970s. One former officer states that general allegations regarding Cyril Smith visiting rent boys were common knowledge in the police at the time. Another alleges that a covert police operation into Smith and his possible indecency with children had garnered enough evidence to obtain the warrant for the arrest of the MP, but that the operation was aborted on the orders of Chief Superintendent Neil Diver, on the basis that it was, quote, too sensitive and too political. So here it appears is evidence of police corruption and yet another missed opportunity to prosecute Cyril Smith. However, we also note that it seems that other police officers involved at the time do not corroborate these allegations. So there is clearly a conflict of evidence to be resolved. We will simply have to see how the evidence looks at the end of these hearings. A second example is the account by Don Hale of a special branch raid on the Bury Messenger in 1984 and the seizure of a dossier apparently given to him by Barbara Castle. Mr. Hale is a journalist with a strong track record of exposing miscarriages of justice, for which he was awarded an OBE. We also know from the historical record that around that time in 1984, in the context of IRA terrorism, the then Home Secretary Leon Britton was seeking to scale up the activities of Special Branch. And we also know that in the 1980s, during the so-called Zircon affair, Special Branch used heavy-handed tactics to seize documents from the journalist Duncan Campbell. With that backdrop, it may be tempting to take Mr. Hale's account at face value. However, there are some obvious issues with his story. A significant issue is the lack of any corroboration of the raid on this office, either from anyone who was present at the time or anyone who heard about it subsequently. This is a raid that, curiously, seems to have left literally no trace at all. Another issue is the way in which Mr. Hale's account of the contents of the Castle dossier appears to have changed quite significantly between the first publication of his story in July 2014 and later versions in 2015. So again, these issues will have to be carefully examined in this hearing. We will return to the question of state cover-up in our closing submissions. We will go where the evidence takes us, and I would encourage everyone following these hearings to do the same. Chair, whatever you eventually conclude about the extent to which the police, security services and others deliberately covered up the abuse of children, one thing is clear. For far too long, with a few honourable exceptions, most of the political parties and state bodies under scrutiny in this inquiry failed to treat the welfare and safeguarding of children as even a factor to be considered, let alone a priority. We have seen within the disclosure to this inquiry that the prime concern of MI5 or government departments, when considering allegations presented to them in relation to prominent figures, was the reputational risk to the government, the risk of blackmail and other security concerns, for example. No one ever seems to consider whether there are children at risk who need to be protected. Whether it was avoidance of political embarrassment or security fears, the welfare of children seems to have been a distant concern. It may well be that in all the talk about conspiracies and VIP paedophile rings, we could be in danger, to some extent, of missing the point. The issue in some cases may not be so much deliberate cover-up or conspiracy. The issue may have been that nobody was actually thinking about the welfare of children at all. To change this requires real cultural change, so that if an allegation of child sexual abuse crosses the desk of a politician or civil servant, then the first thought on everyone's minds should be, are children at risk now, and what can we do to protect them? Chair, we hope the next few weeks of hearings can help to bring about that change of culture. Those are our opening comments. Thank you.
Thank you, Mr. Scorer. Mr. Price.
Madam Chair, thank you. Members of the panel, we heard your imprecation to keep our opening statements within the time limits. Well, I'm afraid I'm going to disappoint you, Madam. We're going to be significantly shorter than the 20 minutes allocated. I make this opening statement on behalf of Esther Baker, a survivor of sexual abuse and a campaigner. And this short statement is intended to introduce Ms. Baker, set in its proper and correct context her involvement in this inquiry, indicate the approach she intends to adopt during this hearing, and highlight some very broad themes she hopes will be covered by the time your report comes to be finalised. Ms. Baker, who was born in 1982, was violently sexually abused since the age of a toddler by men known and unknown to her, mostly in Staffordshire. She has suffered from depression, PTSD, alcoholism, and other physical and mental health problems throughout her life. Aged 13, she underwent the botched, unlicensed termination of a pregnancy, rendering her permanently unable to have children thereafter. She has frequently self-harmed and attempted suicide. Many of her relationships of all kinds have been abusive. The psychological damage caused by child sexual abuse in its victims is profound, and to those who have not been subjected to it, impossible to comprehend. In piecing together her childhood experiences and seeking to understand what happened to her and at whose hands, Ms. Baker has spent most of her life and all of her adult life interacting intensely with police, social services, the NHS, her local authority and other state agencies tasked with investigating child sex abuse and caring for its victims. Certain features of Ms. Baker's abuse have led her and others to believe that it involved men whose status means that her abuse falls within the general remit of this strand of the inquiry. That is one of the reasons why Ms. Baker is here. Ms. Baker's participation in this inquiry has caused considerable controversy and, it is acknowledged, some concern to you, Chair, to the panel, and to Counsel to the inquiry. It has also engendered repeated and concerted attacks upon Ms. Baker on social media, in the national press, and in correspondence to the inquiry. But despite all of that, she is here. And since she is here, it is worth noting that of all the people that the inquiry will hear from over the next few weeks, more than almost all of them, Ms. Baker's life has been consumed in virtually every aspect by the sexual abuse perpetrated against her as a child, by men in relational power to her. Her life since has been consumed by the permanent and crippling effects of that abuse and shaped by the desire for explanations, for justice and for some kind of peace. Those who so glibly attack her and question her involvement in this inquiry would do well to remember how dominant a factor child sexual abuse has been in Ms. Baker's life. Regardless of the identities of her abusers, she is a victim and a survivor, and she's here. Few survivors will be heard from over the next several weeks. Almost all of the people you will hear from will be here in their professional capacities, here because their jobs have brought them into contact or potentially into contact with allegations of child sexual abuse or with corruption in relation to such allegations. They are not victims, but it is acknowledged they have found themselves in the very challenging position of having to react appropriately when confronted by allegations of child sexual abuse. How should they respond? How hard to press? What questions to ask? Who to tell? Who to believe? As the inquiry is learning across its investigations, these are challenges which have tested many of this country's most robust and sophisticated institutions and personnel. And in the face of those considerable challenges, many of those have simply failed victims at every turn. Child sexual abuse is most often perpetrated by men in power who are protected by institutions for whom or with whom they work, often the very institutions that are supposed to protect the vulnerable, but too often end up protecting the abusers. And those institutions and their norms, processes and procedures dictate expectations as to victims' behaviour. We come to expect victims to conform to modes of being victims, modes of suffering, ways of complaining. Nowhere has this been more evident than in Westminster, where the focus is almost always not on the victim, but on the accused. Anyone accused of sexual abuse has a lot to lose, but those in power have perhaps more than most. Even an allegation can ruin a political career for good. This high risk, coupled with other unique or unusual features belonging to powerful men at the heart of government, wealth, ready access to legal resources, pre-existing relationships with the national media, and of course power itself, combine to create an atmosphere of extraordinary hostility for complainants, which has the capacity to deter many and distort the stories of those few brave enough to come forwards. The inquiry now has the opportunity to judge, to an extent which it is hoped by Ms. Baker may be effective, these people and their institutions in how they have lived up to the challenge of dealing with child sexual abuse in this unique set of circumstances. It will read reports of investigations and previous inquiries, study policies, note the lack of policies, and hear from some of those tasked with investigating abuse and corruption related to child sexual abuse. Ms. Baker will be here whilst it does so. And she too may judge, as the inquiry may judge, whether she and others who find themselves in her situation are well served by these people and institutions. Ms. Baker acknowledges that the inquiry will not seek during this hearing to investigate her particular allegations or how the making by her of those allegations has been handled by the institutions to which they were reported. There are, however, three general areas in particular that Ms. Baker hopes the inquiry will shed some light upon, and in which it will, if necessary, recommend appropriate changes. First of all, political parties' HR and whip functions need updating, with clear lines of complaint and investigation, codes of conduct, safeguarding policies and so on, and robust enforcement. There must be transparency so to avoid the perception that discipline is linked to patronage. Secondly, treatment of survivors must not depend upon the identity of the accused. There has been a recent move towards greater protection for those accused of and being investigated for crimes of a sexual nature. This may or may not be warranted, but it is vital that in that debate the rights of victims remain paramount. Finally, the inquiry must address the issue that the wider criminal justice system has a practice, mostly implicit, of treating powerful people differently when it comes to accusations of child sexual abuse. There is in these cases, from the outset at least, a tacit common presumption that the stakes are higher for all involved, and that includes those investigating and the institutions they work for. There is a sense that investigating the powerful risks being more trouble than it is worth. It is certainly often more resource intensive, and the stakes are perceived to be higher. It can be a subtle factor, hard to detect, but if it pervades the many small decisions that make up a single investigation, it has the capacity to skew the overall outcome, and this must be recognised and addressed. The value of this strand of the inquiry to Ms. Baker and other survivors remains potentially very significant. Whilst Ms. Baker understands that she will not, through this process, understand forensically what happened to her as a child, nor at whose hands, this investigation nevertheless has the potential to demonstrate to Ms. Baker and those in her position that the system in which they have been caught up really does care about them more than it cares about protecting the powerful institutions and the men who have traditionally run them. Or if it cannot demonstrate that, then it is the duty of you, Chair, and the panel to make recommendations capable of bringing about real and lasting change to the institutions under investigation.
Thank you, Mr. Price. Mr. Steen.
Good afternoon, Chair, panel members. I appear with Mr. Enright of Howe & Co. on behalf of Mr. Tim Hulbert. Mr. Hulbert's evidence to this inquiry is simple, compelling and deeply disturbing. Mr. Hulbert is a career civil servant who retired from public service as the Director of Bedfordshire Social Services. After that, he moved on to set up a social service consultancy, and he also carried out inspections at various care homes. In late 1977, Mr. Hulbert was employed as a consultant in the Home Office Voluntary Services Unit, the VSU. At the VSU, Mr. Hulbert's duties included providing expert advice to ministers, inspecting and reporting back on organisations receiving voluntary service unit grants, and assessing applications for new grants. On a day around the time of the election of Margaret Thatcher in May '79, Mr. Hulbert saw evidence that the Home Office Voluntary Services Unit, the VSU, was providing substantial monetary support to the Pedophile Information Exchange, PI. Mr. Hulbert worked in the VSU with Mr. Alan Davis, later the Reverend Alan Davis, who was a principal at the VSU. The head of the unit was Clifford Hindley. In approximately 1980, Mr. Hulbert recalls a morning when he took his coffee into Alan Davis's office to have a brief catch-up on what they were both doing. The two men were chatting generally about grants the Home Office was making when Mr. Alan Davis showed Mr. Hulbert an A4 landscape sheet that was open at the back page and said words to the effect of, "Have you seen this?" The document was a quarterly summary of pending grants or grants for renewal, which was circulated in the voluntary service unit to help all staff know what was going on. It consisted of a table with several columns, which included the name of the organisation and the amount of the proposed grant. Mr. Davis pointed out an entry which read WRVS brackets PIE, P-I-E, close brackets. And it was shown as a grant for renewal, and the amount was at least a 5-figure sum. Mr. Hulbert believes that the sum was for tens of thousands of pounds over 3 years. Now, both men expressed surprise at this entry for several reasons. Firstly, although shown as a grant for renewal, neither of them had seen a grant described in these terms before, i.e. the terms WRVS brackets PI. The WRVS being the Women's Royal Voluntary Service, Mr. Hulbert recalls that he and Mr. Davis joked about whether the WRVS were having a national bake-up in reference to the acronym PI. But it was Mr. Alan Davis who suggested to Mr. Hulbert that the acronym PI represented the Pedophile Information Exchange. In the statement from Mr. Alan Davis, dated the 19th of May 2017, Mr. Davis puts it the other way around. In any event, the two men reached the same conclusion. The second reason for their surprise was the juxtaposition of WRVS and PI. The WRVS was a huge national organisation, founded by Lady Reading during World War II, engaged generally in relief and emergency work and things like Meals on Wheels. It should also be noted that this entry, seen by Mr. Hulbert, was seen by him and Mr. Davis at the very time that PI was at its most active. We've heard today from Mr. Altman, Queen's Counsel, in his descriptions of PI activities, its infiltration, discussions with and dealings with other organisations such as the Albany Trust, NCCL and the like, that this was at a time when PI was at the height of its activities. So the entry appeared at that time in the life of PI and its organisational activities. Now, Mr. Davis appeared horrified by the idea that the VSU could be supporting Pye. So Mr. Hulbert, in discussion, told Mr. Davis that he is going to take it up with Clifford Hindley, the head of the unit. And he did so. Not long after, in a meeting with Clifford Hindley, Mr. Hulbert explained what he had seen and expressed his deep disapproval that the VSU appeared to be funding Pye. Mr. Hubert recalls saying something like, "Clifford, what the hell are we doing funding this outfit?" Mr. Hulbert made it very clear to Mr. Hindley his disgust at the aims of Pye and pointed out that the VSU was an interdepartmental unit with a responsibility to coordinate government policy on the voluntary sector. In that conversation with Mr. Hindley, Mr. Hulbert could not have been clearer in identifying the acronym Pye as the Pedophile Information Exchange to Mr. Hindley. And we know this was not a miscommunication because of Mr. Hindley's response. Mr. Hulbert told Mr. Hindley that it was illogical to be helping organisations in conjunction with the Department of Health to promote child protection and at the same time to fund one which was campaigning to remove existing safeguards. So what was Mr. Hindley's response? Mr. Hindley's response was that Pye was a bona fide campaigning organisation, even if its objectives appeared objectionable. He went on. Mr. Hindley explained that it was funded at the request of Special Branch, who he said found it useful to identify people with paedophile inclinations. Further, Mr. Hindley said that it was a grant being extended for a further period and therefore did not require a consultant's input. Of course, you'll recall that Mr. Hulbert at that stage was working as a consultant. So we know that Clifford Hindley did not seek to say or deny that the entry referring to Pye might be about something else. He didn't say it was a misunderstanding or that there was an error being made by Mr. Hulbert. Instead, Clifford Hindley clearly accepted, it was about Pye, the Pedophile Information Exchange, but warned Mr. Hulbert off from making any further inquiries or asking any further questions. About a week or so later, Mr. Hulbert was in the General Office when Brian Chaplin, the principal who worked with Clifford Hindley on the Albany Trust grant and who was responsible for the administrative aspect of the grants, was present. Also present was David Skagel, senior principal who was about to replace Brian Chaplin, and the registry clerk Irene Cole. Mr. Hulbert again asked to see the WRVS file, which Mr. Brian Chaplin had in his hand. David Skagel said he could not have it, as it was nothing to do with a consultant. That was the only time Mr. Hulbert was ever refused access to any file while he worked at the VSU. Mr. Hulbert has maintained his account for 40 years, and it has not been dismissed in the corridors of power. Mr. Hulbert's evidence of these matters have been the subject of 2 formal investigations. The Home Office independent investigation into alleged payment of Home Office funding to the Pedophile Information Exchange reporting in 2014, and found that Mr. Hulbert's evidence was credible. The Wanless and Whittam Review, which was published on the 11th of November 2014, and on the same day of the publication of the findings of the Wanless Whittam Review, the Prime Minister, Theresa May, then the Home Secretary, said, "The right place for consideration of these matters, apart from live criminal allegations, which should be dealt with by the police, is the panel inquiry into child abuse that I have established. That inquiry will be comprehensive. The panel will look at institutions in this country, gain access to all relevant paperwork and take evidence from survivors and witnesses so that we can expose what has been going on. It may take time." And the Prime Minister went on to say, "And I know we have slipped twice in our attempts to get this right, but I am determined that we will succeed in doing so. And I know that the whole House shares my determination." It is notable, we suggest, that the Prime Minister stated her belief in relation to Mr Hulbert's evidence that we have slipped twice in our attempts to get this right, and stated that this inquiry would be the vehicle to ascertain the truth about various matters in relation to the Home Office and historic child sexual abuse. So what do we know now as a result of the evidence uncovered thus far by this inquiry? Well, we know that the Home Office funded the Albany Trust at a time when the Albany Trust provided material support to the Pedophile Information Exchange. We know that the Albany Trust provided this support to PI with the Home Office's knowledge and using the resources provided by the Home Office. So what was the Albany Trust trying to achieve through this association and work with PI? For at least one answer to that, we can turn to the minutes of the meetings of the trustees of the Albany Trust on the 19th of January 1977. And that gives the reasons for not publishing a PI pamphlet that the Trust and PI had been working on. Those minutes demonstrate that the reasons the trustees of the Albany Trust eventually agreed not to publish a PI pamphlet was partly that it would not advance the understanding and acceptance of paedophiles. Anthony Gray, managing trustee of the Albany Trust, held meetings with PI and corresponded with them on a number of occasions. And these include, and there are other examples, letter from the Pedophile Information Exchange alerting the Albany Trust to a change of address, letter from the Albany Trust complimenting Keith Hose from PI for his courage in standing up and speaking. So what then of Mr Hulbert's central evidence that he saw a grant report that indicated that the Home Office was actively considering the renewal of a 3-year grant to PI via the WRVS? Well, it was certainly at a background time when PI was active. And we know that funding was being provided to the Albany Trust. So one of the key things that Wanless and Whitten tried to look at in their review was whether there were accounting records at the Home Office and at WRVS that showed what grants were received from the Home Office to the WRVS and what they were used for. The Home Office were able to provide the Wanless and Whitten review with evidence of the very large grants to the WRVS right up until 1977, and then full records of grants made to WRVS after 1980. However, the Wanless and Whitten review were told by the Home Office and the WRVS that there were no records for the years 1977 to 1980, the years which would have included funding, as what Mr Hulbert saw was a potential renewal of that funding. And we agree with the evidence that's going to be provided by Mr Wanless and Mr Whitten Queen's counsel that it is inconceivable that the VSU provided no funding to the WRVS in that period. It is deeply suspicious that the financial records of both the Home Office and it seems the WRVS are missing for, and only for, the very 3 years in which Mr Hulbert says that a grant was made from the Home Office, VSU to PI via WRVS. In the period 1977, the WRVS received over £1 million a year from the Home Office. In 1980, the WRVS received 3.7 million for that single year. A good place to bury funding for PI. So it is, as Mr Wanless and Mr Whitten say, inconceivable that the WRVS received literally millions of pounds of public money in the missing 3-year periods. So where did the records go? Were they lost or destroyed or misplaced or hidden? We suggest that the Home Office must explain the missing records relating to millions of pounds of public money. This is an area that must be investigated to the fullest possible extent. There are two sources, the Home Office and the WRVS. Both must be compelled to provide the fullest evidence and disclosure regarding the grants made and received in the period 1977 to 1980. Howe & Co., my instructing solicitors, have written to the inquiry 4 times since November 2018 asking that steps to track these records are urgently taken to obtain that vital evidence. Each time the request has been denied. Chair, the Prime Minister herself charged this inquiry with investigating Mr Hulbert's evidence that the Home Office provided public monies to support the Pedophile Information Exchange. You, we suggest, with your colleagues, cannot and should not permit any stone to remain unturned. The missing Home Office and WRVS financial records for this key period must be found and interrogated. So in conclusion, Mr Hulbert was and is an honourable man, a good public servant, who has honestly set out the same account of what he saw those many years ago. He has told a simple and uncomplicated truth. I saw a document that indicated that the Home Office were funding the Pedophile Information Exchange, and I challenged that with the relevant Home Office official, Mr Hindley. Mr Hindley accepted the entry for what it was and accepted that this related to funding the Pedophile Information Exchange. This was not said by Mr Hindley to be an error or a mistake. Despite pressure, internal Home Office reviews, missing crucial evidence and ministerial statements, Mr Hulbert's evidence remains unchanged and unchallenged. Mr Hulbert's account is, we suggest, compelling in its simplicity and alarming in its implication. Thank you for listening today.
Thank you, Mr Steen. Mr Griffin.
Chair, panel, I represent the Home Office. I'm assisted by 2 junior counsel, Rachna Gokani and Amelia Walker, and we are instructed by Daniel Rapport of the Government Legal Department, and we work with a team from the Home Office. Chair, as Mr Altman said, you granted call participant status to the Home Office, also in a representative capacity for Her Majesty's government. And in that role, the Home Office has coordinated the response to some cross-government requests from the inquiry for evidence, while the inquiry has already also been able to go direct to departments as appropriate. And during the hearings, we are here to assist with liaison between the inquiry and other relevant government departments and bodies. In this short opening statement, I'd like to provide a non-exhaustive overview of where the Home Office and other government departments fit into the issues under consideration in the Westminster investigation, and to touch on the evidence that you will be receiving and hearing. Moving really to week 2, in the early stages of week 2, you will hear evidence about Sir Peter Morrison and connected matters. And during that time, the inquiry will call a witness from the security service. He provides evidence not just about the Morrison issue, but about other issues too, including the Hayman issue. And you will also hear, as Mr Altman said, from Baroness Eliza Manningham-Buller, who worked within MI5's Secretariat team in 1986, and she provides information relevant to the Morrison issue too. She, as you probably know, was herself subsequently appointed Director General. The inquiry also plans to hear about the honours system during the second week of evidence. And Helen McNamara, who is Director General at the Cabinet Office, will be called to give evidence about how the system operates. And at the start of the third week, you will be hearing evidence about the Pedophile Information Exchange. You've already heard about the Wanless and Whittam review and the 2 internal independent Home Office reviews that preceded it. You have also received a statement from a Home Office witness in connection with the Wanless-Whittam review process. That witness was head of the Secretariat for that review from July 2014 to July 2015. And in week 3, the inquiry will also go on to consider safeguarding. The Home Office has assisted the inquiry by marshalling evidence from all central government departments in connection with their safeguarding and child protection policies. And that evidence has taken the form of witness statements and the production of the policies and connected materials. That is all amongst the material that your expert, Professor Thoburn, has looked at and considered. And amongst that evidence are statements and documentation about safeguarding from 2 Directors General at the Home Office. And as you've been told, you will be hearing about safeguarding matters also from a witness from the Secret Intelligence Service, and you have received a witness statement from a witness from GCHQ, and the Security Service witness may also cover safeguarding matters. The Home Office, Cabinet Office, and other government departments and bodies have made substantial disclosure to the Westminster investigation. And that's clear from the various tranches of material that has been made available by the inquiry to core participants. In short, Chair, it's the intention of the Home Office and government more widely to contribute significantly to the work of the inquiry in this investigation. Thank you very much.
Thank you, Mr. Griffin. Mr. Robertson.
Good afternoon, Chair, ladies and gentlemen. Where there's smoke, there's fire is not always true. Sometimes there's just a smoke machine. And in this case, it belched the smoke that got in the eyes of Tom Watson and various febrile journalists who started a moral panic over a Westminster child abuse network gang, which your inquiry has been tasked to investigate. And after 3 years of considerable expenditure of public time and money, it ends with the conclusion that you heard from your counsel at the end of his speech this morning, and I quote, "There is no evidence of a Westminster paedophile network or of any attempts to cover up or suppress the existence of such a network." That is the conclusion of Commander Jerome. You'll hear him on Thursday, after 72 separate inquiries, police inquiries, commissions, and the like. Mr. Proctor, whose name was occasionally thrown in to add a bit of density to the smoke, welcomes that conclusion. It's what he's maintained all along and written about in a book. I represent him together with Adam Wagner and Mark Stevens. He plays a small but nonetheless significant part in your inquiry because he's a genuine victim. Not a victim of sex abuse, but a victim of false accusations of sex abuse. Accusations by liars and fantasists. His innocence and his suffering from those false allegations were movingly described by Sir Richard Henriques in his report, and you well know that he's received a fulsome apology for ever doubting his innocence from Sir Bernard Hogan-Howe on behalf of the Metropolitan Police Service. We appreciate the good legal reasons why we're not going into Operation Midland at this stage, but we suggest that once those legal reasons pass, that you should have a part 2 of this inquiry looking at Operation Midland for the simple reason that it represents a massive institutional failing by the Metropolitan Police Service. And unless it is looked at, that failing will be repeated. It will deter complainants about sex abuse if they think that the body they're complaining about to is so incompetent that it spends 16 months investigating complaints that are obviously ridiculous. So for that reason, we will ask you to recommend or to consider, once the legal reasons have passed, which they should in a few months' time, to hold a part 2. Let me begin by telling you a little about Mr. Proctor. He was the MP for Basildon, elected in 1979, for Billericay in 1983. And he was one of the very small group of concerned on the far right of Mrs. Thatcher's Conservative government, dubbed by an infamous Panorama programme as Maggie's militant tendency. The militant tendency, of course, was the name given to entryists into the Labour Party, Derek Hatton and co., who were thought to be antipathetic to that party's values, and so it was similarly thought that Mr. Proctor and his colleagues were antipathetic to true conservative values. They stood for restriction on immigration. And even worse, shock horror, they wanted Britain to leave the European Union. Mr. Proctor has a footnote in British political history as our first Brexiteer. But the point is that his views, however mainstream they may be now, were at the time controversial, and they made him many enemies in his own party as well as in the opposition. And the media went out looking for a weakness, and they found it in his homosexuality. That sexual orientation is entirely acceptable today, but you have to remember, back in the 70s and 80s, the judge, after the Vassal inquiry, the judges will say, oh, well, homosexuality might be legalized, but it's not acceptable. It's a character defect. And although it was legalized for over 21 in 1967, it was still looked on askance. In 1976, the Daily Mail hounded Maureen Colquhoun out of politics. She was an MP, a Labour MP, whom it revealed was a lesbian. Then, of course, in 1977, there was the Gay News case, convicted of blasphemy for publishing a poem suggesting that homosexuals could go to heaven. In 1980, there was the massive attack on Gays the Word bookshop, and that was notable because the opposition to it was led by one Cyril Smith, who was the first openly gay MP, and that wasn't until the early 1980s. He was followed by Matthew Parris later on. So this is a time when homosexuality is considered a Cold War risk, hence the concern about Peter Morrison, and the confusion between homosexuality and paedophilia is common, and it is in many of the papers that you'll see. Well, by the end of 1986, Mr. Proctor was exposed by a tabloid who sent a 19-year-old youth and trapped him into admitting that they had had sex, and he pleaded guilty to what was then an offence of having sex with a man under 21. It wouldn't be an offence now. The law was changed, dropped to 18 in 1994 and to 16, making it a heterosexual equivalent in 2001. But nonetheless, there is Mr. Proctor. He was fined at Bow Street. His conviction would never be prosecuted today. It couldn't be. It's not a crime. But people don't remember that. People don't remember that he's rehabilitated under the Rehabilitation of Offenders Act. Oh no, he's a name there in the memory because the press coverage was sensationalistic for weeks. So he is well known as someone convicted of having underage sex. And there his name is out there as someone to be added when you're fabricating a list of well-connected paedophiles. In fact, after Mr. Proctor was convicted, he left Parliament and has lived a life of utter obscurity, hard-working because he's been managing an estate in the north. And then these allegations have caused him, as you've seen, considerable anguish. Now, so I was saying, before I was interrupted, that this was, Settle and his team of 6 highly cleared detectives proved that the Elm Guest House list was a fabrication. And his reports went to the Gold Group, which was a group in the Metropolitan Police Force headed by a commander. Now, an example, please, that's my solicitor. An example of the kind of malicious rumour that Mr. Proctor has had to put up with was when the press contacted the police to tell them that he'd been beaten up by a group of boys, ex-boys, who'd grown up and were out to have a reprisal beating of him because they'd been interfered with by him in Elm Guest House. That was the sort of thing that Mr. Settle had to inquire into, and of course it was totally untrue. The men who'd beaten him up, he was running a dress shop at that time in Richmond, were simply homophobes, and he was the victim of a homosexual hate crime. So there he is out there, vulnerable, and a name to be attached to lists being fabricated of alleged abusers. Now, you're told by counsel that you shouldn't care about whether the accusations that are made public in this inquiry are true or false. You should be a privileged platform for the most hideous allegations against some of the more distinguished politicians of our time. And it was a matter that will be reported this evening and tomorrow morning. I don't act for those people, but nonetheless, you should be careful of taking the advice of your counsel. People sometimes say the worst mistake they made in their life was to take the advice of their counsel. You're not obliged to, and it is not acceptable to allow yourself to be used as a platform for allegations that are plainly false. And so we invite you to say, when you make your report, that there is no substance in them. Your Commander Jerome has, in effect, said that, and you can endorse his view, because in August 2017, you said that you would look at the source of these allegations, and it seems to us that it would be reasonable for you to look at the source of those allegations and make some comment upon them. The source of the Elm Guest House allegations being Mr. Fay, a convicted fraudster who had no first-hand knowledge at all, other than that which he received from a convicted criminal. To look at Mr. Gilbertthorpe and the source of that extraordinary allegation about senior ministers at Tory party conferences taking cocaine and rent boys. On the evening when, that terrible evening in 1984, when the Grand Hotel was blown up. They can all remember where they were at that night. Mr. Proctor can remember exactly where he was. It wasn't at any drug-fueled sex orgy in the Grand Hotel. He was having dinner with his constituency chair and his wife. So you see, the source of these allegations, Mr. Gilbert thought was paid £12,000, was it, by the Mirror offered him that. He wanted 40,000. We don't know how much he was actually paid for it. He's a bankrupt. He's a malicious man disappointed by failure to be a Tory councillor. He's an alcoholic, indeed. And when he was called in to assist your inquiry, he refused. The interview goes on for pages. Every now and again, he makes an extraordinary outburst about God and death. Quite why he does that, you can consider his mental stability from his interview. Now, should you actually in your report say something about these allegations, whether they're likely to be true or not? We think it would be only fair if you did. And should you have part 2 to look at Operation Midland, we think it would be useful if you did, because it was the very reason, Operation Midland, why you were set up. The fact is, millions were wasted on a disastrous investigation, taking resources away from the investigation of real victims of child abuse and setting a precedent that may prevent others from reporting genuine cases. And this gets us perhaps to the nub of the matter: how to investigate allegations of child abuse effectively, bearing in mind the presumption of innocence. False allegations against VIPs are damaging, not only because they cause unjustified suffering, but because they usually receive much more publicity. And when the investigation is abandoned, then disbelief in the system can deter genuine complainants in the future. We hope you will endorse the recommendations of Sir Richard Henriques that, first of all, complainants should not be registered as victims, but as complainants, until there's corroboration. Care should be taken not to disclose their identities until they're arrested. That must mean no tricks of the sort that were played on Mr. Proctor. The Met Police pretended that they were not giving information away about the search of his house or his arrest. So they said, oh yes, we've searched the home of a 70-year-old man from Grantham. The press knew immediately. That was confirmation that they were after Harvey Proctor. So no more tricks like that. And of course, there's the golden rule that police should never act on a complaint by using powers of search and seizure and arrest unless the complaint is corroborated, unless there's some evidence to confirm it. That's particularly important with historical complaints of child sex abuse made against political figures or celebrities, precisely because they're public figures. They'll have enemies, there'll be malice, they'll face a media which will pay handsomely for such stories, and further incentive will be a payout from the Criminal Injuries Compensation Commission. So unless there's striking similarities, corroboration is not provided simply by the number of complaints against one celebrity. Once rumour takes wing, the same allegation will be repeated multiple times. In the case of the guest house list, they all arise from one discreditable and discredited source. In principle, MPs should be treated the same as every other citizen. But in the case of people of public significance, could I put it this way, in the case where police know that there will be massive publicity when they go for a search warrant in secret or take or arrest, in those cases there needs to be, firstly, some CPS oversight of the investigation to check that it's not subject to political interference. And secondly, there should be any warrant that's granted should be brought before a district judge, not a lay justice. We all know that police have their favourite lay justices who will give them a rubber stamp for everything they apply for. The problem in the Cliff Richard case and in the Harvey Proctor case was Mr. Justice Mann indicated with Cliff Richard, Mr. Justice Henriques with Harvey Proctor. The search warrants should not have been granted, but they were granted by lay justices. There was no transcript, there never is. There must be a transcript of all the applications for search and seizure warrants, and there must be brought before a district judge, not the favourite JP of the local police. That's necessary for transparency. It's necessary to ensure that there is no political interference. And you should look also at the role of the law in covering up child abuse by wealthy or famous people. There's evidence here before you of the misuse of the Official Secrets Act, both in the Cyril Smith investigation to stop it, and there is the customs official from Dover who thought that Leon Britton had driven through with a pile of child pornography, but he couldn't, he felt, disclose it because he'd signed the Official Secrets Act. Well, of course, if he had, it might have been realized that it wasn't, in fact, Leon Britton, which seems likely. But really, is this practice of forcing public servants to sign the Official Secrets Act still in force? It acts as a kind of NDA, a non-disclosure agreement. If you sign the Official Secrets Act, you're intimidated against going to the police if you notice misbehaviour or misconduct. So 50 years ago, Lord Franks had a committee where he said signing the Official Secrets Act is just a bluff. It has no effect, but it clearly has this interiorum effect, which is deterring people from exposing wrongdoing. And that is a good example, that customs official who felt the child porn could not be disclosed to police. Then, of course, there's the law of libel. It's well known Jimmy Savile would have been exposed by the press had it not been for the law of libel. They were told by George Carman, you cannot publish this. And so Savile went his unmerry way. The reason for that is essentially because libel is the only civil law in which the burden of proof is on the defendant, in this case on the media. And that frequently, where there are reasonable suspicions that should be published, the media can't publish them. So further reform of the law of libel is, we think, necessary to encourage the press to play its proper part in exposing wrongdoing. Mr. Proctor has suffered from the media, but he doesn't blame journalists. He wants them to play that legitimate part in helping to expose child molesters. And he at least doesn't have to prove his innocence. It's been certified by the Metropolitan Police Commissioner. Commander Jerome will confirm before you that there's not a scintilla of evidence of a network, a metropolitan, a Westminster child abuse network. And there's, we hope, I can give you a statement from that we've taken from DCI Settle, which you can put on your website and draw conclusions about the culture in Scotland Yard, certainly about as an institution.
Mr. Robertson, would you please wind up your remarks?
Yes, of course.
Thank you.
By all means. We will give you that as in the hope that you'll put it on your website. I won't say anything further about I don't act for others, but I will end by saying that, of course, this inquiry has detected a number of individual cover-ups. Sir Peter Hayman, for sure. Cyril Smith, most properly, was not properly investigated. But the moral panic started by Tom Watson about Westminster paedophile ring had no basis. It was just smoke without fire. And one of your tasks is to investigate interventions by politicians. You might look at interventions that encourage the pursuit of false complaints, as well as interventions of the other kind. Nobody can object to MPs raising matters of public importance, but all that can be asked of them is that they show a modicum of intelligence in assessing those allegations and, like the Metropolitan Police Commissioner, apologise when those allegations prove groundless. Thank you.
Thank you, Mr. Robertson. We'll now take our afternoon break and return at 3:45. Please sit. Ms. Leake.
I make this brief opening statement on behalf of the Metropolitan Police Commissioner. When the then Home Secretary announced that this inquiry would be established, there was much speculation, rumour and suspicion. This centred upon allegations of child sexual abuse by MPs and prominent people connected with Westminster. There were assertions and rumours about police cover-ups and about investigations being shut down because of collusion between police and MPs. Over the last 4 years, the IOPC and the Metropolitan Police Service have dedicated considerable resources to investigating these allegations. Allegations which are essentially of police misconduct. The inquiry will hear evidence about those investigations over the course of this first week of evidence. Before addressing what is within the scope of this investigation, we note that you, Chair, have expressly ruled that certain matters will not fall within that scope. In particular, the inquiry does not propose to investigate and determine whether child sexual abuse in fact occurred, save where there have been convictions. Rather, the focus will be on the institutional responses to allegations of child sexual abuse, both at the time and since. The distinction is an important one. Whilst we do not suggest that the inquiry can or should come to any conclusions as to whether any particular individual did in fact commit child sexual abuse, the strength and circumstances of the initial complaint provide necessary context in understanding the responses of institutions such as the Metropolitan Police Service. The inquiry will hear evidence from Commander Catherine Roper, the Metropolitan Police Commander with responsibility for professional standards. She, along with Mr. Mahaffey of the IOPC, will explain how complaints and allegations of police misconduct are received and investigated. We anticipate that they will explain to you the outcome of the scoping exercises and operations conducted by the Metropolitan Police Service, including investigations conducted subject to the oversight of the IOPC. Those investigations have been conducted by officers attached to the Metropolitan Police Service's Operation Winter Key. As you may recall from other strands of this inquiry, Winter Key was established in June 2015 in order to investigate, first of all, allegations of non-recent child sexual abuse involving people of public prominence or institutions, and secondly, allegations that such abuse was covered up by, amongst others, police officers. Led by an experienced senior officer, Winter Key has been staffed by specialist investigators well used to handling the most sensitive and complex cases. Winter Key presently still has over 80 officers and staff. They have approached these matters with an open mind and a determination to identify wrongdoing. They have followed the evidence where it has taken them. No fear or favour has been shown to anyone in a prominent position. On any objective and fair analysis, it is clear that the Metropolitan Police Service, through Operation Winter Key, has approached its task with diligence and a commitment to uncovering the truth. In this respect, we ask the inquiry to note the convictions that Operation Winter Key has secured, some of which have been examined in other strands within this inquiry. The inquiry will note the sheer number of matters which the MPS has investigated. We invite you also to note the very low threshold which has deliberately been applied by Operation Winter Key in conjunction with the IOPC to ensure that all allegations, irrespective of their age, the source of the allegation, or whether there exists any corroborative evidence, have been accorded proper consideration. Of those investigations, the assessment made by the MPS is that there is currently insufficient evidence in respect of any one case to bring criminal or disciplinary action, although in a few cases, if the subject of the allegation had still been alive, a formal interview would have been conducted. We welcome the inquiry's critical scrutiny of those investigations. The inquiry will also consider the much-discussed allegations concerning Elm Guesthouse. Commander Neil Jerome will explain the investigations which have been conducted. In short, despite much public speculation, including by those within the political and media establishments, there is currently insufficient evidence to substantiate any allegation or suspicion of misconduct in the way in which officers dealt with allegations of child sexual abuse. We welcome the inquiry examining the allegations that have been made and, perhaps for the first time, the public consideration of the institutional response to those allegations. Commander Jerome and Commander Roper are both here in court today. Both will give evidence and will do their best to contribute to your understanding of the Metropolitan Police Service's actions. But they are also here to listen. The Commissioner recognises that these matters have caused profound public debate and concern and welcomes the light which this inquiry will throw on them. She is of the view that where the investigations have not been substantiated, this should not be a source for complacency. In some instances, it has been possible to establish that the allegation is without foundation. In many more, the passage of time, the fading of memories, the destruction of documents in accordance with policy, and the death of those involved has meant that it has not been possible to establish one way or another whether the allegations are true. The actions of previous generations of police officers have been judged against policies and investigative standards in force at the time. Inaction cannot be dismissed as being of its time without further critical examination. However, we do invite the inquiry to note that many of the allegations have their origins in events in the 1960s, 70s, and 80s. Societal attitudes and the law have changed enormously. Allegations that might have been made against men in the 1960s, 70s, and 80s may not be made in 2019. In addition, the way in which the police investigate and pursue allegations of crime has also changed because of advances in computing, the availability of CCTV, and DNA testing. The culture of policing and the manner in which complaints and allegations of wrongdoing are handled have also changed. There now exists a duty to report and challenge improper conduct. Protections for whistleblowers have been strengthened. Chair, as an organisation, the Metropolitan Police Service remains open-minded. Commander Roper will remain throughout the evidence. Should any new and credible information or evidence emerge, the Metropolitan Police Service will not hesitate to take action. Chair, I do not propose to address anything said in opening on Mr. Proctor's behalf about Operation Midland. Suffice to say that what Mr. Jerome will say, what Commander Jerome will say, may be slightly more nuanced than has been suggested. Chair, we do not suggest that the concerns of those from whom the inquiry will hear should be in any way minimised. We recognise the deep concern generated by the subject matter of this investigation. As you will have seen, across the various investigations, the desire to avoid scandal and the wish to preserve reputation have, for too long, overridden the need to protect children. I echo Mr. Scorer's words on behalf of a number of complainants. Allegations of state cover-up need to be approached with an open mind, but also with rigour and common sense. Chair, it is plainly right that the powerful are held to account, and that includes the police. We are here to assist in that process.
Thank you, Ms. Lee. And finally, Ms. Graham.
Madam Chair and members of the panel, I would like to make a few remarks on behalf of the Labour Party who instruct me. The Labour Party welcomes this inquiry and we recognise the importance of your task in furthering the safety and welfare of children by guarding them against sexual abuse and exploitation. Now, we know, of course, that in this module you'll be furthering that end by publicly exploring past events or allegations related to prominent figures at Westminster and how they were investigated or handled. And also in what your leading counsel has referred to as strand 7 of your investigation, you'll also be examining the adequacy of the existing safeguarding and child protection policies in place within political parties, government departments and agencies. Now, Madam, I know, of course, that the past events include public concerns about the historic involvement of prominent figures in Westminster or on the national political scene in child sexual abuse or in allegedly covering up such abuse, or the responses made by them to allegations of abuse. And I'll come back to those issues, if I may, very briefly at the end of these opening comments. But I would like to start by making a few observations about the current landscape and the processes and culture of the Labour Party now. We are here in this inquiry as core participants because we recognise the importance of your work and we wish both to assist it and to learn from it wherever possible. We understand that we have safeguarding responsibilities and we take them seriously. That is a key reason why we have sought representation and designation as core participants. The Labour Party is a membership organisation that admits members from age 14, so young people can engage with the activities of the party from the age of 14. And we're also aware, of course, that children or young people may come into contact with or interact with Labour Party members through the party's activities without themselves being members. As we set out in the witness statement of Mr. Ian McNichol in the inquiry statement dated the 10th of January 2018, we recognise our responsibility to safeguard and promote the welfare of children and young people and to provide them with a welcoming and safe environment when they engage with Labour Party activities or its members. The statement of Mr. McNichol outlined the work that the Labour Party has been undertaking since September 2016, when the Deputy Leader of the Labour Party, Mr. Tom Watson, reported on the safeguarding context to the party's National Executive Committee. And Mr. Watson recommended that the NEC adopt the Labour Party's safeguarding and child protection policy and the Labour Party's safeguarding code of conduct. Both of these policies had been developed in consultation with advisors from the NSPCC and they were duly adopted. It was also agreed that further detailed work on safeguarding policies and practice would be undertaken over the following months. So, for example, the Labour Party set up the Safeguarding and Complaints Unit to direct and manage the safeguarding procedures to protect children, young people and adults at risk who are members or interact with the Labour Party. Now, fuller details of all these processes were set out in the witness statement of Mr. McNichol and in its various attachments, and I won't spend more time outlining their contents. But, for example, there is safeguarding guidance clearly and readily available on the Labour Party website about issues such as how to report a concern and who to speak to or to email. Madam, as was discussed this morning, your inquiry has helpfully commissioned an expert report from Professor June Tobin, from whom we understand we will be hearing. And it's not for me to set out the contents of that report, but we know from what your inquiry counsel has said that her review examines the adequacy of the existing safeguarding and child protection policies in place within political parties, as well as within government departments and agencies. And as part of her review, she obviously examined the policies of the Labour Party, as outlined in the statement from Mr McNichol that I've just been summarising. We welcome the comments that she makes in her report, and also the recommendations concerning good practice, which she addresses both to parties and government departments. And we do believe that the extensive material that she examines reflects the importance that's attached to those issues by the Labour Party. Professor Tobin was aware that the policies that were outlined in Mr McNichol's statement of January 2018 was still evolving, and that further work was being undertaken. So at the end of last week, we submitted a further statement, this time from Ms Jenny Formby, who was appointed the General Secretary of the Labour Party in April 2018. This statement updates the inquiry on further work done since Mr McNichol's statement was submitted, and deals in particular with the policies adopted by the NEC in January 2019. I'm sorry that this information wasn't with you and Professor Tobin at an earlier date, but you will appreciate that the work has been continuing, so the landscape changes. Again, I don't want to spend time detailing material that can easily be read, but I will highlight a few aspects of the materials provided. There has been, for example, the development of policy in areas such as how to organise safe events, extensive investment in staff training and e-learning packages for both staff and members, strengthening of the system of regional safeguarding leads, which is a network of 16 members of staff currently, and continuing work with the NSPCC. The NSPCC has assisted with developing child protection procedures, but in addition, there's also been work developing and trialling an audit process with the NSPCC to review how the Labour Party responds to safeguarding concerns and allegations, and to ensure that the safeguarding procedures not only represent best practice, but are held up to independent scrutiny. And these are significant examples, we would submit, of work to embed policy into practice and to give the welfare of children the centrality that it deserves. We hope, Madam, that despite any pressures of time, this additional material too will be provided to Professor Tobin, and we would welcome any further comments on it or input from her. We are seeking to develop not only effective policies, but to ensure their effective implementation. And we wish to build not only processes, but also a culture which keeps children and young people safe and well. We recognise the importance of strong leadership and accountability, training and providing guidance and resources to all members to achieve this culture. Madam Chairman, it may well be that these matters, that is, the current policies and safeguarding processes of political parties, take up relatively little time, at least in the oral hearings that will occupy you over the next 3 to 4 weeks. We know that for a good part of that time you will be looking at more historic concerns about the involvement of prominent figures in Westminster or on the national political scene, both in the context of allegations of involvement in sexual abuse, child sexual abuse, but also at how such allegations were investigated or treated by those with the responsibility or power to take action. As to that, Madam, there are a wide range of individuals and institutions within the scope of this investigation. We are confident that through your inquiry council team that your investigation into those issues and the various individuals will be performed thoroughly, fairly and impartially. I have no comments to make, at least at this stage, in relation to the actions of any individuals linked to or members of the Labour Party. That is a matter for your team to explore over the next few weeks. But I have drawn attention, or sought to draw attention, to the present position in order to highlight the party's commitment to getting safeguarding issues right now. We've pointed to our continued work in this area, and we will ensure that any findings or lessons from the past events that you are investigating will be examined by us and used to test our current policies and procedures. In that way, we would hope that the work of this investigation will help the Labour Party to build an organisation and a culture that protects children and young people and promotes their welfare and development. Thank you very much.
Thank you, Ms Green.
Well, Chair, that is the totality of the statements from court participants you are to hear this afternoon, and we will turn, as I said earlier, to the evidence at 10 o'clock tomorrow morning.
Thank you, Mr Alton.
Thank you.